He's a founder of CEDA, which is one of the major organizations that deal with mediation. And in, I think, 2010 and 2011, he was awarded Global Shipping and Maritime Lawyer of the Year by Who's Who Legal. So we're very privileged to have Jonathan here to speak today, and he is going to speak about mediation and arbitration. Thank you, Jonathan.
This is certainly the most memorable conference venue at which I've been asked to speak. I would say thank you to Francesco and his wonderful team, but that will eat into my 8 minutes, so I won't. I'm here to speak about the interplay between arbitration and mediation, and what I'd like to do in the next 8 minutes or so is cover firstly the importance of the topic, secondly what is mediation, what are its advantages, thirdly what is the attitude of the English courts, and fourthly examine whether arbitrators have similar powers to those exercised by the judges in the English courts. So the importance of the topic. The maritime world is highly productive of disputes, and the majority of those disputes get referred to London. Wherever I go in the world, it's fair to say that there's high praise for English proceedings, but there's also concern about the costs of proceedings. And it's in relation to costs in particular that mediation has a big part to play. So that's the importance. What is mediation? Well, it is, the way it operates in England, simply a facilitated settlement negotiation. So the mediator doesn't make any decision, he doesn't express a view, he doesn't suggest settlement terms. He's there to facilitate the parties in arriving at a settlement. And you may think, against that background, well, not all that many can succeed. It may be counterintuitive, but despite the mediator's lack of coercive powers, there's reliable data in England suggesting that something approaching 90% of mediations are in fact successful. What then are the key advantages of mediation? The first two really go hand in hand, cost and speed. It's possible to bring a mediation on within a period of weeks or perhaps months, rather than the perhaps years that you may be tied up in court or arbitration. And if a typical court or arbitration hearing may run for, say, 5 days or so, it's most unusual for a mediation hearing to run more than 1 day. And so it's no exaggeration to think in terms of overall cost savings of 80%, if not more. But there's, of course, another head of costs which isn't so often talked about, and that is the diversion of senior management time wrapped up in running a heavy piece of litigation. So cost, speed, clear advantage. A third advantage is under the heading of preservation of business relationships. Now, we all invest a lot of time in building up relationships, and it's very easy to burn such a relationship in the context of what can easily become acrimonious court or arbitration proceedings. Given that, as I said before, in mediation it is the parties' settlement facilitated by the mediator, but it's still the parties' decision whether they come to a settlement, that acrimony isn't there, and the relationship itself survives. Indeed, that brings me on to the fourth point, which is really creative solutions. Now, in court or arbitration, the arbitrator or judge has very limited options. He can give the claimant some or all of what the claimant is claiming, or the same in relation to any counterclaim, and that's about it. In mediation, on the other hand, there's no limit to the solutions that are possible. And I'll just give one brief example, which involved a dispute between an oil major charterer and a ship owner. In a falling market, the charterer cancelled. There was an issue as to whether that was justified, and arbitration proceedings were pending. A mediation then took place, and the end result of that mediation was to park the original dispute between the parties, and what came out of the mediation was a new long-term contract whereby the oil major gave the ship owner first refusal, specified voyages, specified cargoes over quite a lengthy period, which frankly was hugely more valuable to the ship owner than succeeding on his original claim would have been. Attitude of English courts. Oh, in 2 minutes. Okay, let me very briefly set the context. In England, the successful party is awarded his costs, but the judge does have a discretion to decide otherwise. And there's now been quite a string of cases in England where one party has proposed mediation to the other. That party has declined to mediate. The case has then gone ahead to court, and the party who declined mediation has succeeded, has won in court. So normally would get his costs. The judges have now said in a string of such cases that where there has been an unreasonable refusal to mediate, or indeed in one case which went to the Court of Appeal, where one party simply ignored the other party's mediation proposal, then the courts will depart from the usual order as to costs, and the successful party will be deprived of the costs that he would otherwise have been awarded. And then in my remaining minute, do arbitrators have the same power? I submit that they do. In other words, that the arbitrators can do just what the judges in England are now doing, which is to stay arbitration proceedings in favor of mediation, and if one party declines to mediate, then to make an adverse costs order at the end of the proceedings. Finally, why is this important? You may say that there are now more and more often multi-tier dispute resolution clauses which may provide in first paragraph for good faith negotiation, second paragraph mediation, third paragraph arbitration or court proceedings. That's perfectly correct, and there is English authority for the proposition that not only the mediation provision, but even a good faith discussions that the court can enforce such an agreement. But those provisions work in an inflexible manner. They work sequentially. So it's first the negotiation, then the mediation, then the arbitration. That is not the clever way to do things. In many cases, you may want to start the court or arbitration proceedings and then start the mediation when sufficient evidence is there to intelligently discuss the case. I hope there are some questions so we can develop some of these points further during the panel discussion, but I will have Sir Bernard on my tail very soon if I don't stop. Thank you.